Hello friends, very warm welcome to my business laws channel. Friends, till now from the ITI 2000, I have made 3 videos and this will be the last video for this ITI 2000. So the headings which I will be covering are the chapter's title is Cyber Contravention, Adjudication, Appellate Tribunal and Offences. The frequently asked questions in Delhi University and other examinations I would like to cover from this chapter in this video. So the first heading is before you, which is penalties and compensation. Describe the various provisions pertaining to penalties and compensation provided under the Information Technology Act 2000. And then second question is relating to justice dispensation system for cyber crimes under the IT Act. So write a short note on cyber contraventions and who is adjudicating officer, which are the various factors which are to be considered by adjudicating officer, while deciding the quantum of compensation. Then differentiate between cyber contravention and cyber offences. And apart from this, meaning and punishment of various offences. Say, for example, tampering with computer source documents, publishing or transmitting obscene material in electronic form, or cyber terrorism, and identity theft. Like this, many more offences are also there. The question can be asked regarding meaning, and then you have to write the provisions regarding that, and what are the penal provisions relating to the cyber offence which has been asked to you in the question. So the very first heading in this chapter is penalties and compensation. Penalties and compensation, friends, they have been provided under section 43 to 45. So there are 4 points regarding this which I would like to discuss. First point is penalty and compensation for damage to computer system or computer network. Section 43 provides that if a person commits any of the following prohibited acts, he shall be liable to pay damages by way of compensation, and the amount of damages should not exceed ₹1 crore to the affected party. So these prohibited acts I would like to take up now. First is access with authority. If he accesses or secures access to such computer system or computer network without the consent of the owner. Then he downloads, copies, extracts any data, computer database or information from such computer system or computer network. Introduction of computer contaminant or virus. If he introduces or causes to be introduced any computer contaminant or computer virus into another computer system or computer network, including information or data held or stored in any removable storage medium. Then damage to computer database. If he damages or causes to be damaged any computer system or computer network, data, computer database, or any other program which resides in such computer system or computer network. So friends, all these are the prohibited acts. Many more points are: he disrupts or causes disruption to the stated computer resources. He does not allow the access to the computer system or computer network. He cannot do like this. If he does it, it means he is committing that act which has been prohibited. Providing assistance to facilitate access. Now, he is providing the assistance to some other person to facilitate access to a computer system or computer network. So, these are all in the contraventions of the provisions of the IT Act. Charging the services to the account of another. Nobody is allowed to charge the services to the account of another. If he is availing certain benefit, then he must pay for that. If he does it, it means he is committing the prohibited act. Destruction, deletion or alteration or information. If he destroys, deletes or alters any information which resides in the computer resource or diminishes its value or utility or affects it by any means. Stealing, concealing, destroying computer source code. Not only he commits the above prohibited act, but he steals, conceals, or destroys, or alters, this computer source code. So this last point has been inserted by Information Technology Amendment Act 2008. Second point is here compensation for failure to protect data. This was also inserted by ITAA 2008 under section 43A. If body corporate is dealing with the sensitive personal data, passwords or PIN number, then certain precautions are security practices are not followed. Then in that case, such body corporate shall be liable to pay damages by way of compensation. The maximum limit is 5 crore rupees. This compensation should not exceed 5 crore rupees. Then penalty for failure to furnish information, return or report. Some return is to be furnished or report has to be furnished, but the company or the person has committed default. The legal requirements have not been met. Okay, so then also there are 3 provisions for this. The first provision is penalty for failure to furnishing any document, return or report to CCA or CA. He shall be liable to a penalty which will not exceed ₹1,50,000. Second is penalty for failure in filing return or furnishing information. Return has not been filed, or some important information has not been furnished with the concerned authorities within the specified time. He shall be liable to a penalty not exceeding 5,000 for every day during which such default continues. So if he delays for 1 day, it means 5,000 extra. If he delays for 2 days, it means 5,000 for 1 day. It means total penalty will be 10,000 rupees. Penalty for failure to maintenance of books of accounts or records, he shall be liable to a penalty which will not exceed ₹10,000 for every day. Remember, friends, in the earlier point, the penalty was for a delay for 1 day, the penalty was ₹5,000. But here in the third point, penalty for 1 day is 10,000. Moving ahead, point number 4 is penalty for contravention of rules or regulations. If certain rules or regulations are contravened, for which no penalty has been provided, he shall be liable to pay compensation not exceeding ₹25,000 to the person who has been affected by such contravention. Now, friends, I will take up the heading Justice Dispensation System for Cyber Law. IT Act 2000 has provided 4 authorities. First is CCA, second is AO, third is AT, and fourth is High Court. Now, the diagram is before you. Appellate Tribunal, we call it AT, okay, and then CCA, you all are familiar, and adjudicating officer. Adjudicating officer always deals with the contraventions made under the IT Act. If anybody has contravened the provisions, who will decide the provisions have been contravened by anybody? For that, officer is appointed by the central government. That officer is known as adjudicating officer or AO. He will exercise the powers which have been, provided to civil court, or his jurisdiction has been laid down. He will be dealing with the matters for claims up to ₹5 crore. So his jurisdiction is up to ₹5 crore. Then CCA acts as a regulator of certifying authorities. Friends, I have told you under the heading functions of CCA. Functions of CCA, I have discussed that CCA always acts as a regulator of certifying authorities. CAs are always regulated by CCA. Then he ensures adherence to the provisions of IT Act. He always ensures that all provisions of IT Act must be adhered. Then, if any order has been passed by CCA or adjudicating officer, but party is aggrieved by the order, then, party has a right to make an appeal to a appellate tribunal within a period of 45 days. Or if the party could not file the appeal within a period of 45 days from the date of receipt of order, and there was sufficient reason for that, then the AT can also permit submission of appeal within the extended period. Now, if AT has reversed the order or modified the order, still aggrieved party is not satisfied with the order of AT, then the aggrieved party will have the right to make an appeal to the High Court. So friends, all these points I have explained, and now I would like to explain the heading Adjudication on Contravention. Section 46 provides that it becomes necessary to find out whether any person has contravened the provisions of the Act, or any rule, regulation, direction, order made thereunder. Because violation will result in payment of penalty or compensation. For this, already I have told you just now, the central government has provided an officer who is known as adjudicating officer. He will conduct the inquiry, and then he will decide that whether penalty should be imposed upon the defaulter or not. Now, what will be the qualifications and jurisdiction of adjudicating officer? Such officer shall not be below the rank of a director in the Government of India, or he shall be an equivalent officer of the state government. The AO appointed under Section 46(1) shall exercise jurisdiction to adjudicate matters in which the claim for injury or damage does not exceed 5 crore rupees. Already I have told you, friends, and if it is more than 5 crore, then the authority shall vest with the competent court. And this point was inserted by ITAA 2008. Now, where more than one AOs are appointed, the central government shall specify the order, the matters and places with respect to which such officers shall exercise their jurisdiction. Now, moving ahead, friends, now the next heading is factors to be taken into account by the adjudicating officer. Now, while deciding the quantum of compensation, which are the various factors which are to be considered by AO? These factors are, three factors are there. First one is the amount of gain of unfair advantage. To what extent unfair advantage has been derived by the defaulter? The amount of loss caused to any person as a result of the default. To what extent the loss has been suffered by the injured party? And then, was the default of repetitive nature, or it was committed by the defaulter for the first time or second time? So all these factors will be considered while deciding about the quantum of punishment. If the AO is satisfied with that the person has committed the contraventions, he may impose such penalty or award such compensation as he thinks fit in accordance with the provisions of that section. And now, friends, I would like to talk about AT. AT, I have told you, all IT related matters, they are always taken to AT. So we can say AT is appellate tribunal, is the lower court, the civil court for all IT related matters. The telecom dispute settlement and appellate established under authority established under Section 14 of the Telecom Authority of India Act 1997 as a part of 14th of Chapter 6 of Finance Act 2017 with effect from 26 May 2017. Be the appellate tribunal for the purposes of this Act. The said appellate tribunal shall exercise the jurisdiction, powers, authority conferred on it by or under this Act. The central government shall specify by notification all the matters and places in relation to which AT will exercise its powers or jurisdiction. And now, friends, I would like to discuss the various provisions relating to appeal. What is appeal? what is the time limit within which appeal can be made, who can make appeal, when the person loses his right to make an appeal. So all these provisions I will discuss. What is appeal? Appeal is a request made by the aggrieved party, to modify or to reverse an order. Okay, and more point, who can make appeal? Any person aggrieved by an order which is made by CCA or adjudicating officer A under this act may prefer an appeal to AT, appellate tribunal. Now, when the person loses his right to make an appeal, where the order has been made with the consent of the parties. What is the procedure for appeal? Every appeal shall be filed within a period of 45 days, which I already have discussed in this video, from the date of receipt of order made by the CCA or AO. The appellate tribunal may entertain an appeal after the expiry of the stated period of 45 days. I told you, friends, if there is sufficient cause for that, for late submission of the appeal, then the AT is satisfied with the cause. Then extended period also appeal may be submitted. On receipt of an appeal under section 57, subsection 1, AT may, after giving an opportunity of being heard to the parties to the appeal, pass an order. But sufficient opportunity should be given to the parties. They should be heard at least. And after hearing only, the AT should pass an order. Whatever order the AT thinks better. It may confirm, may modify, set aside the order against which an appeal has been made. Copy of the order. Copy of the order shall be given to the parties to appeal, the concerned controller, or adjudicating officer. Time period for disposal of appeal. All the appeals should be disposed of within a period of 6 months from the date of receipt of the appeal. And now, friends, I'll take up the last heading under this chapter, which is distinction between cyber contravention and cyber offences. First is the meaning. Cyber contravention is a breach or abuse of a rule or procedure of a cyber law. Cyber offense is execution of an act which is prohibited or forbidden by the cyber law. And you all know cyber law has been provided under the IT Act 2000. Nature. What is the nature of each one? Cyber contraventions primarily deal with authorized or illegal access to computer system or computer network. Whereas cyber offenses deal with the serious cyber crimes related to so many cyber crimes are there. Cyber virus, cyber stalking, cyber terrorism. Okay, now these crimes may relate to computer system or computer network. ATM frauds may be there. This is also a cyber crime. Then prosecution. Cyber contravention may result in civil prosecution, means the defaulting party will be asked to pay monetary compensation. But cyber offences may result in criminal prosecution. The offender may be put in the jail, or he may be asked to pay fine, or both the types of punishment may be asked to bear. Investigation. Who has the authority to investigate? CCA or AO. In case of cyber contravention, they have the authority to investigate any cyber contravention. But police officer below the rank of Deputy Superintendent of Police has the authority to investigate any cyber offense. Before year 2009, this authority was with the inspector. But after that, inspector was substituted by DSP, Deputy Superintendent of Police. Then consequences. In case of cyber contravention, the offender is liable to pay damages by way of compensation, and the amount should not exceed 1 crore rupees. But in case of cyber offense, the offender is punishable with imprisonment up to a certain period or fine up to a certain amount or with both. So depending upon the offense, violation of privacy or cyber terrorism or cyber stalking. Okay, so there is a different penal provision for different offences. So he may be given imprisonment which will be 1 year, 2 years or 3 years, or life imprisonment Okay, or he may be asked to pay fine 1 lakh, 2 lakh, 3 lakh, depending upon the offence. So, friends, 5 points of distinction between cyber contravention and cyber offence. This is all from my side regarding this IT Act 2000. I hope you will understand the content, you will like the content. Do press on the bell icon to get notifications of my future videos. Do subscribe to my channel if you have not subscribed yet. Friends, stay healthy and stay blessed always. All the best to all the students who have their examination in the near future, that is in the month of March, or maybe in April or May. Okay friends, we'll meet soon. Goodbye.